Okay, sir, start करिए.
Welcome all the shareholders of Sadhav Engineering Limited. As we scheduled our meeting for the merger of Sadhav Engineering, Sadhav Infrastructure, I now hand over the meeting as statutory requirement to our chairman of the meeting.
Thank you, Sharvi. Ladies and gentlemen, I, Sandeep Patel, Chairman appointed by the Honorable National Company Law Tribunal Ahmedabad Bench for the meeting, welcomes you all at the today's NCLT convened meeting of shareholders of Sadhav Engineering Limited, which is being held through video conferencing. As far as quorum is concerned, in this meeting, 33 members are present through video conferencing. As requisite quorum is present, I declare the meeting to be in order. Now I request Mr. Tushar Shah to proceed with the meeting. Thank you.
Thank you, sir. I hope all of you are safe and in good health and stay that way. I would like to inform that the meeting is being conveyed through video conferencing under the order of Honorable National Company Law Tribunal, Ahmedabad Branch, pursuant to the provision of Section 230, 232 of the Companies Act 2013, for the purpose of considering scheme of amalgamation of Sadhav Infrastructure Project Limited with Sadhav Engineering Limited and the respective shareholders and creditors. I will take you through certain points regarding e-voting participation and voting at this meeting. The company has provided facility to the equity shareholder of the applicant transferring company to vote by electronic means, both through remote e-voting and e-voting during the equity shareholder meeting. Equity shareholder joining the meeting through video conferencing OAVM who have not already casted their vote by means of remote e-voting shall be able to exercise their right to vote through e-voting at the meeting. The said facility of e-voting during the meeting shall be kept open for 15 minutes after conclusion of this meeting. All the equity shareholders who have joined this meeting are by default placed on the mute to avoid any disturbance from background noise and ensure smooth and seamless conduct of the meeting. Those equity shareholders who have registered themselves as a speaker for the meeting would be allowed to speak one by one later on. The company has provided remote e-voting facility of CDSL to the equity shareholders for exercising their voting right in respect of business mentioned in the notice of equity shareholder. Further, it is also informed that remote e-voting facility also kept open from Tuesday 26 January 2020 9 AM till Thursday 28 January 2021 5 PM. The equity shareholders who have not voted to remote e-voting facility can cast their vote through e-voting facility during this meeting. Equity shareholders who have casted their vote by remote e-voting prior to meeting may also join the meeting through VC or AVM, but shall not be entitled to cast their vote again. The resolution prescribed in the notice of equity shareholder of the company will be passed through e-voting process only. Since the notice convening the meeting along with the explanatory statement is already circulated in advance, I propose to take it as read. The following resolution is proposed for the approval by equity shareholders by requisite majority as prescribed under Section 230 to 232 of the Companies Act 2013, read with Rule 6 of the Companies Compromise Arrangement and Amalgamation Rules 2016. Now I read the resolution. Resolve that pursuant to the provision of Section 230 to 232 of the Companies Act 2013, read with the Companies Compromise Arrangement and Amalgamation Rule 2016 and other applicable provisions, if any, of the Companies Act 2013, the rules, circulars and notification made thereunder, including any statutory modification or reenactment thereof, as may be applicable, the Security and Exchange Code of India Circular Number CFD DIN 3 CIR 2017/21, dated 10th day of March 2017, and the observation letter issued by the BSE Limited and National Stock Exchange of India Limited, and enabling provision in the memorandum and articles of association of the company, and subject to the approval by Honorable National Company Law Tribunal Ahmedabad Bench, and subject to other approvals, permission, and sanctions of regulatory and other authority as may be necessary, and subject to condition and modification as may be prescribed or imposed by NCLT or by any regulatory or other authority while granting such consent approvals and permission which may be agreed to by the board of directors of applicant transferring company, hereinafter referred to as the board, which shall come to be deemed to be and include one or more committee constituted by the board or any person which the board may nominate to exercise its power, including powers conferred by the resolution. The scheme of amalgamation of Sadhav Infrastructure Project Limited and Sadhav Engineering Limited and the respective shareholders and creditors with effect from the appointed date as mentioned in the scheme be and is hereby approved. Resolved further that the board of directors or a company secretary of the company be and are severally authorized to do all such act, deeds, matters, and things as may it its absolute discretion deemed requisite, desirable, appropriate, or necessary to give effect to this resolution and effectively implement an arrangement embodied in the scheme and to accept such a modification, amendment, limitation, and condition, if any, which may be required and or imposed by NCLT while sanctioning the arrangement embodied in the scheme or by any other authority under law, or as may be required for the purpose of resolving any question or doubt or difficulty that may arise, including passing of such accounting entries and making such adjustment in the books of accounts as considered necessary in giving effect to the scheme as the board may deem fit and proper. Now, regarding the question answers, before I put the resolution to vote, I just want to inform that none of the equity shareholder has registered as a speaker for the meeting. Hence, we move towards further proceeding of the meeting. Now, I take the further proceeding of the meeting and request the shareholders to vote on the resolution as mentioned in the notice calling this meeting. Equity shareholders may kind to note that pursuant to provision of section 109 of the Companies Act 2013, CS Ashish Shah, practicing company secretary, is appointed as a scrutinizer to conduct the voting process. This being the NCLT convened meeting, the result will be announced on or before 31st January 2021 at the corporate office of the company, and result for remote e-voting and e-voting during the meeting will be placed on the website of the company. It will also be submitted to the stock exchanges as per the relevant provision of the Companies Act and listing regulations. Business as per agenda having transacted, I hereby declare the meeting to be concluded with the permission of chair and request also chairman to conclude the meeting. And I thank you all for cooperating with me in smooth conduct of the meeting. Thank you. Stay and safe. I will request chairman of the meeting to conclude the meeting for the merger.
Since the business as per the agenda has been transacted, I declare the meeting to be concluded.
Thank you.
Thank you.
Thank you.
Thank you.